Welcome everyone. This is Rafael Carmona from the ICDR. I'm a director based in New York, and I also help with our young and international group of the ICDR. And I want to begin the webinar just taking one moment of your time to remind you that you can join as a YNI associate. If you look for us, you can Google us, ICDR Young and International or YNI. You're going to find our website, and there you will find registration forms in English and in Spanish. And you will also be able to find there the recordings of our previous programs so that you can review them if you want. We're also in LinkedIn. So if you look for our group, also ICDR Young and International, you'll be able to find us. And we'll be also posting there about their programs and initiatives. So with a very brief introduction, we have a great panel ahead of us. I don't want to take any more of your time, and I'll give the floor to our moderator today, Rodrigo, who's also part of our ICDR YNI Executive Board. Rodrigo, the floor is yours.
Thank you, Rafa, for putting this together and for the kind invitation to moderate this panel. Thank you all, the panelists and attendees for being here today. Let's move now to the topic of this event. We'll talk about how the ICDR decision making process works in practice. And to address that, we have a great panel. Let's start with Tom Ventron, who is the VP of the ICDR in New York for more than 17 years, and with whom I had the pleasure to work with as well for a couple of years. We'll talk about the history, guidelines, and best practice of the Review Council. We'll also have Kelly Turner, who is with the AAA in Chicago for more than 8 years, currently as senior counsel. She will address the Review Council from a domestic perspective. Liz Robertson, who is with the ICDR in New York for more than 7 years, currently as director. She will touch on the filing requirements and administrative jurisdiction to initiate an arbitration. Ana Lombardia, who is with the ICDR in Miami as director for almost 4 years. She will address disputes regarding the seat of arbitration, location of hearings, and number of arbitrators. And last but not least, Janet Quiroz, who is with the ICDR in Houston as director as well for almost 7 years. She will talk about arbitrator challenges. So please feel free to ask any questions you may have in the chat section. The idea here is to leave time for more interaction with the audience. To learn more about the Review Council, you can also go to icdr.org/council, where you find the guidelines and review standards. So I will now defer to Tom. Please, the camera is yours, Tom.
Thank you, Rodrigo, and thank you, Rafael, and good day to all, wherever you may be seated. Happy you could join us today. Happy to be here to speak a little bit about the ICDR's International Administrative Review Council, or what we refer to as ARC. This was all, and this program fits right in because this is all a little bit about transparency. So the International ARC was launched in 2018, and it was modeled after our colleagues in our American Arbitration Association's domestic group and case management, whose program launched in 2013. One of the slight criticisms we received in years past was a question about transparency and how decisions were made. So we have historically, the AAA has been around well over 90 years, 95 years. So we've been making these decisions. That's what an institution does. And we've been making these decisions for a long time, but people wanted to know how the decisions were made in certain instances. So what we did was launch the ARC. We modified the program from the domestic side just a slight bit, and Kelly's going to touch on some of that in a little bit and tell you where we stand from that angle. But I just want to go over briefly what it is we do and how we do it. And then my colleagues from the ICDR will talk more specifically about each of the issues that we address. So the International Administrative Review Council is in place to decide issues on cases, administrative issues on cases in the following. We decide all challenges to arbitrator service. We decide disputes regarding the locale or place of hearing. Now, as many of you know, there is a difference between locale and place versus locale and seat versus the actual physical location of a hearing. We'll decide those issues too, but we do make an initial determination on locale and seat. We decide disputes regarding the number of arbitrators, believe it or not, when a clause is silent, and also the language of the arbitration we may have to decide at times. And finally, we decide challenges to what I refer to as administrative jurisdiction. And what that is did the claimant have the proper authority to file this claim, this arbitration matter under the contract? And do we, the ICDR, the AAA, have the authority to administer that? This is not legal jurisdiction. We do not get involved in the substantive arguments in that regard. This is, again, what I refer to as administrative jurisdiction. All of these issues are presented to us primarily on, predominantly on ICDR managed cases, of course. Cases filed with us, the issue comes up. But this is an offer that we put out there to ad hoc arbitrations as well. When dealing with an ad hoc arbitration, you may have an issue with an arbitrator and nowhere to turn. So if the parties could agree, we will step in and serve in this sole capacity. We will not administer the case in any other way, but will serve as a review counsel to decide possibly the challenge of an arbitrator or other issues if they so agree. It would all be done by submission. The parties would have to agree. Let me talk a little bit about the council itself as it exists today. The council consists of 6 ICDR executives and 1 former AAA executive who happens to be a former general counsel for the American Arbitration Association. Each session that I'll describe in a moment has 3 voting members. So on a rotating basis, that group of 6 gets rotated with the single external member and has to have 3 voting members to hear the challenge, to hear the dispute. So every session includes 2 AAA ICDR executives and our 1 former general counsel. As of March of this year, this process was finally codified in the rules. So we've been in place again since 2018, but in March 2021, we launched a new set of international rules. And in Article 5, brand new rule, it briefly explains the role and capacity of the International Administrative Review Council. I just want to point out here, and this is explained in that rule, that we make an initial determination, except for challenges, which is a final determination. We only make initial determinations in all other issues. Those issues can then be readdressed by the tribunal once appointed. But in order not to slow down the process, stop the process, cause them extensive argument, we make an initial determination and then allow the parties to readdress if they still have a challenge based on jurisdiction and the proper filing requirements, the seat of the arbitration, or the locale. We will let the tribunal decide that. They're the ultimate decision maker. So the council meets once a week. A case issue is presented by the director responsible for the case. So one of my colleagues on this call, Liz, Jeanette, Anna, will make a presentation to the council based on what has been submitted to them, and they will talk about the process of obtaining comments from the parties and the like. The 3 council members then discuss and vote on the result. All decisions require a majority, and that's why there are 3 members. So it's at least a 2-to-1 vote and majority for whatever the decision is, and let's use challenge as an example for reaffirmation or removal. And no decision is reasoned. We do not provide reasonings, nor do we record our council sessions. So this is open conversation, back and forth, a discussion of the submissions and the arguments put forth, and then a vote as to the decision on the issue. And just lastly, to give you a little idea of what we have accomplished, and this is since 2019, January 2019, not 18, we have decided over 225 issues in over 200 separate cases. The numbers obviously differ because each case could have multiple issues attached to it. So Kelly, I would turn to you, and just if you could, for our attendees who may be predominantly working in international, but may come across and do some work in our domestic AAA offices, how this might differ a little bit, or a little touch on that, if you would.
Yeah, sure. Thanks, Tom. So the domestic ARC, as I'll refer to it, as Tom said, has been around since 2013. The format of things is fairly similar to the international ARC. We have our voting members. There are 8 executives and a former executive. And then I'm also the legal liaison to ARC. Before I was senior counsel, I was the chair of ARC. So I've been involved for a long time. We don't hear seat issues because that's not an issue domestically. So we will hear locale, where the city where the hearing should take place. Domestic ARC decides that. We don't decide number of arbitrators, and language has never been an issue that's raised to us. I think it's always just presumed it's English. Domestic ARC hears only these issues. So we hear filing requirements, locale, and arbitrator objections, challenges to arbitrators, only in cases that fall under our large complex case procedures. So generally commercial and construction. Occasionally it'll be a large case within under the employment rules, but we have the discretion to hear those issues in non-LCC, non-large complex cases, based on the chair's analysis of the dispute. Similar to international ARC, we also have a separate set of procedures for non-administered cases, so private ad hoc arbitration cases, to decide objections to arbitrators. That's the only issue that domestic ARC will take. And we've decided, I know, 3 or 4 of those. There haven't been a lot, but we do it every now and then. And before international ARC was formed, we've decided maybe a couple ICDR cases as well, just because there was, they needed a place to have these decisions made. We decide annually, or have decided annually, about 150 to 175 issues. And like Tom said, that's not necessarily cases, because there are cases that might have 2 issues submitted at once. Sometimes it's filing requirements and locale, or there are times where a case has locale submitted and then 4 months later has an objection to an arbitrator, and we will count that separately. Most of our submissions are challenges to arbitrators. So it's been about 70% of the issues submitted are arbitrator challenges. Most of those we reaffirm, although sometimes it's kind of a 60-40, so not equal, but still closer, closer to that. And then with the remainder of the 30-ish% being locale and filing requirements. And similar to international ARC, we have, out of the 8 voting members, we have a panel of 3 decide every case. We have the case manager or vice president or someone familiar with the case present it based on the papers, and the panel's decision is a majority decision. We have been tracking more recently whether it's unanimous decision or not. I didn't pull those statistics. More often than not, it's unanimous, but definitely not always. And then similar to international ARC, we don't provide our rationale for the decision. We just provide the ultimate decision itself, and locale and filing requirements can be taken up again with the arbitrator. And in fact, they often are. And on occasion, ARC is overruled, or the arbitrator reaches a different decision. And then objections to arbitrators is conclusive. So that's not something that should go before the panel. And yeah, it's been working. It seems like it's working really well. We have, similar to international ARC, we meet on a weekly basis. We also probably once every couple of months, meet on an emergency basis. Usually it's where there's a hearing going forward in a week or two, and then objection to an arbitrator is raised. And so we don't want to wait till our Tuesday meeting to make that decision. And so we will convene at least 3 members on an emergency basis to review the parties' submissions, which are then received or requested on an expedited basis versus the timing we might normally give for just regular oral submissions. So yeah, so that's how domestic art works. Very, very similar.
And if I may, because Kelly brought up a quick point, and then I'll turn it to you, Rodrigo, to move along with the program. She mentioned the rules, and I mentioned the rules. We in the International Center manage cases under all sets of rules. So not only our own international rules, but we also manage cases under the AAA's domestic, commercial, construction, employment rules, and we manage cases under the UNCITRAL rules as well. All cases will and can go to the ARC, not just international rules cases. So if that contract clause calls for AAA commercial rules and there's a dispute of any sort, that will go to ARC as well, despite there not being a specific codified rule that refers to ARC. But I just wanted to make that clear as well in terms of process. So I will stop there and turn it back to Rodrigo.
Thank you, Tom. Let's now move to Liz to talk about the filing requirements and administrative jurisdiction to initiate an arbitration. So Liz, what are the filing requirements reviewed by the council, and how the council affirms its administrative jurisdictions, please?
Thank you, Rodrigo. So the administrator will sometimes receive from a party an objection to our administrative jurisdiction, or generally to the jurisdiction or arbitrability of the claims asserted. As Tom mentioned at the top, the first thing we'll advise the parties in this situation is that the ICDR as administrator is not authorized to make any legal jurisdiction or arbitrability rulings or determinations. These legal rulings must be made by a court or the arbitral tribunal. However, the ICDR Administrative Review Council may review the issue of administrative jurisdiction. That is, whether the filing requirements contained in the applicable administrative rules have been met. So as an example, let's use the filing requirements under the 2021 ICDR International Arbitration Rules. There, the requirements are outlined in Article 2, providing that the notice of arbitration shall contain a demand, contact details of all parties or representatives, a copy of the entire arbitration clause or agreement, description of the claim, the facts, the relief sought, and the appropriate filing fee. So R4 under the AAA commercial rules contains the commercial rule filing requirements, and the other AAA rule sets, construction rules, employment rules, those contain similar filing requirements provisions as well. So the ICDR Administrative Review Council, as we said, will review filing requirements under whichever of the AAA rule sets applies. And that's how we would handle an objection to administrative jurisdiction. The council will review the case file and the party's written contentions as to whether the filing party has met those requirements in whichever rules apply. And it's important to note here again that this decision on administrative jurisdiction is a threshold administrative determination. The council's decision on administrative jurisdiction, if affirmed by the council, may of course be reviewed by the tribunal once appointed. If the council determines that the filing party has met the requirements, the ICDR will proceed with administration unless the parties agree otherwise or court orders to stay the matter. So the filing requirements challenge will then be made part of the case file, and then the parties can submit any objections to the council's determination to the tribunal for review. So that's the basic outline for IRC's procedure for filing requirements and administrative jurisdiction. Are there, do we have any audience questions or?
Not yet, Liz, but I think that's a useful and informative information about how to initiate and how the ICDR affirms its administrative jurisdiction. So now let's turn to Anna to talk about the seat of arbitration, location of hearings, and number of arbitrators, and how the council review all these disputes. So please, Anna, if you could
Sure.
talk about
Thank
these
you.
issues.
Thanks, Rodrigo. Yes, these are two of the most addressed topics and issues addressed by the council. It is, there are common requests, and these are issues that are often disputed by the parties at the beginning of the cases. The first one would be the place of the arbitration, although I have to clarify, as Tom said at the beginning of the webinar, that there is a distinction between the place of arbitration or the seat of arbitration or locale and the place of the hearing. Both issues can be submitted to the council for determination, but typically we normally address the first one, the one that refers to the seat of arbitration or the place of arbitration, because it entails, it may have some effect after the award is rendered. We normally include in our awards a reference as to the place where the award has been rendered or issued for the purposes of the New York Convention. So the ICDR rules provide in their articles 5 and 19 that the ICDR will make an initial determination as to the seat that can be, or it is subject to a final determination or a ultimate decision by the tribunal if the issue is still disputed after our determination. And then the commercial rules provide, because as Kelly indicated, the domestic council or Administrative Review Council do not address the matter of the locale of the seat of arbitration. They may decide as to the place of the hearing. The rules of the commercial division provide that this will be also initially determined by the AAA or the ICDR in this case. We consider certain factors when we present our cases for the council to determine and to decide on this matter. I personally like to present a brief description of the main features of the case, including and considering describing all these factors so that the council can address them and consider them separately. These are, generally speaking, the applicable law and any other specific or relevant factors we may consider. But also, when we decide on the seat, I also use most of the factors typically considered to decide on the place of arbitration, on the place of the hearings, which are the location of the parties, the location of the witnesses, the location of the tribunal, location of counsel, where there is going to be a site that needs to be inspected, where are the materials, when is or where is the contract supposed to be performed, applicable law as well, whether there is an ongoing court action that may have any kind of effect. So the way I do it is I normally in our, the document we normally prepare for the council is I include a description of the case, and I include a description of all these factors so that the tribunal can decide. The decision is unreasoned, is subject to final determination by the tribunal when it comes to the seat or the place of the hearings. And generally speaking, we try to find that place that has, the strongest ties to the dispute and the parties. That would be my comments as to the seat or the place of the hearings. The note that I have to add as to the place of the hearings is that the rules provide that the tribunal can meet and can arrange for the meetings to be held anywhere else. That's why the place of the hearings issue is normally addressed later in the process, and the tribunal normally is the one who makes that determination for the convenience of the tribunal or the parties. So generally speaking, the issue that we most often address is the one about the place of arbitration. The second question I was going to talk about, and is also a very, very common issue we need to address in the council, is the number of arbitrators. This is an issue that appears disputed at the very earliest stage of the proceedings, when we have when we first have the chance to meet with the parties and hold that administrative conference call and address that issue. Sometimes the clause provides for a number of arbitrators. Sometimes the clause is silent, and that is when we have the parties may be, that may be a disputed issue because claimant keeps generally, not always, but typically they want to keep things under control, not too expensive. They don't want to incur in many expenses or arbitration fees. They prefer a sole arbitrator, and respondents prefer a 3-member panel. So what we do is we review in the first place what the arbitration clause provides, and when the arbitration clause is silent, we go and resort to the rules. As Tom indicated, we manage cases in the ICDR according to different sets of rules. And if we are managing the case under the ICDR rules, the default of the following provision is that the arbitration will be heard by a sole arbitrator, unless we decide that due to other factors, the complexity of the case, it is more appropriate that the matter is heard by a panel of 3 members. A 3-member tribunal. When we are managing cases under the commercial rules, generally speaking, there is a provision in the section of the rules that refers to the large and complex cases that provides that for those disputes that are over $1 million, the matter will be heard by a panel of 3 members. But again, it's always a matter of determination by the AAA-ICDR and ultimately the Administrative Review Council. When we are managing the case under the nonneutral rules, the defaulting rule provides for a 3-member panel, and that's what we normally do typically. As I said, this is a decision. This is one of the few decisions that is conclusive, and it is not typically subject to any kind of review by the tribunal. What we consider, what factors we consider, as I said, well, not only the amount of controversy or the amount of the disputes, but also whether there are, several parties. If this is a multi-party case, if this is a case with several claims, counterclaims, cross claims, whether I was going to say sometimes. The arbitration clause or the parties request for the tribunal to include a member that meets certain background requirements that are very specific. Sometimes, if that is the case, we might want to consider a bigger panel so that we have people with different backgrounds, not only that specific background, but also a more general background, or the other way around. So these are typically the factors and circumstances we consider when we address whether it's going to be 1 arbitrator or 3 arbitrators.
Thank you, Anna. Thank you very much for your comments. Janet, now regarding the arbitrator challenges, how does it work at the Review Council, please?
Sure, Rodrigo, thank you very much for the opportunity to talk to you about these issues that we cover in the administration of our cases on a very regular basis. So, well, as you know, the rules provide for mainly 3 reasons why an arbitrator may be challenged, and those are basically lack of independence, lack of impartiality. And after the recent modifications to the rules in March, there was also added a new reason to challenge an arbitrator, which is failing to perform the arbitrator's duties. This change is consistent with the obligation of the arbitrators to act according to the Code of Ethics for arbitrators in commercial disputes that was also added in Article 14 on in this recent amendments. The arbitrators were actually de facto requested to act under this Code of Ethics before, but as Tom mentioned, in this, intention to fully be transparent, this was also included in Article 14. So those are the reasons why an arbitrator may be challenged. The process of how to file a challenge is described in the rules as well. We basically receive one round of briefs in relation to the challenge. We do not normally request additional briefs. Although, in very, very exceptional circumstances, those may be allowed. We do not encourage that. It's fair to say. We have to understand that this is a party-driven process. So we will mainly hear or consider the parties' arguments regarding the challenge we are reviewing. So a couple of things that are also, or the parties also need to consider, is that the challenge shall be raised at the very first opportunity they have to, whenever or as soon as they are aware of the reason why a challenge may be filed. So this is something that it's important. Also, an arbitrator may be challenged on different times. I mean, several times during the proceeding, but whenever we receive a second challenge to the same arbitrator, it needs to be related to new issues that give a rise to reasonable doubts on how the arbitrator is performing their duties and lack of independence and impartiality. So it's important that we learn that this needs to be a new issue in the case, not something that IARC has already considered. I would also like to mention that for me, it has been very, very interesting how the IARC considered the arguments of the parties. Again, this is a party-driven process, but also, as Anna mentioned, when we make our presentation of the case, IARC has a very, very wide, consideration of all the issues that are relevant to the case. And just to mention an example, whenever I have a case seated in California, it may be a little bit different the way IARC considers the disclosures and the challenge itself, and as opposed to cases that are seated in a different place. So just those comments. Again, the Code of Ethics, it's important. I also wanted to make a comment about the statistics that we've had. Tom mentioned a little bit about that, but I want to bring your attention to, for example, in 2019, IARC considered 91 issues in different cases, and 58% of those issues were challenges. In 2020, from 71 issues, 57% were challenges. And in 2021 through September 30, from 61 issues, 36% were challenges. So as you can see, in some majority, challenges are a very an issue and a topic that keeps IARC very busy. And again, this is one of the very important administrative part of our rules and of our administration, because as mentioned before, this is one of the conclusive decisions that we made during the process. So that said, I'm open to any questions you may have.
And
Thank
Janet,
you,
I just wanted to add on, because I know in domestic ARC, and I assume in the international ARC, but y'all can correct me if I'm wrong, that the majority of objections to arbitrators that we see are based on the alleged lack of independence or partiality. So we don't see very many under the inability or refusal to perform duties. On rare occasion we see those, but usually it's something about, bias or partiality is what's being alleged. And I know both in our review standards, both for domestic ARC as well as for international ARC, the council looks at 4 items which it weighs in deciding the arbitrator objection, which are as to whether the alleged conflict is direct, continuing, substantial, and recent. And everything is really, really fact specific. I can tell you from domestic ARC. And so that, we really dig into, as Yanette said, what's being challenged. So if there's a disclosure that we might think like, oh, that seems a little bit problematic, but a party hasn't objected based on that disclosure, ARC won't make a decision on it because that's not part of the challenge. But it really is drilling in, is it something ongoing? Was it in the past? How far in the past was it? Is it this arbitrator, this arbitrator's law firm, their prior law firm? We look at all those types of issues. I remember one case that involved, it was some prior representation by the arbitrator's law firm, but it was some kind of like property title check, and the firm billed like $2,000. So under the substantial prong, that's not substantial, but it's very, very fact specific.
Thank you, Kelly. We have here an interesting question from Steve Sertelman. He asks, when the arbitration agreement provides for party-appointed arbitrators, the appointees often have some prior relationship to the appointing party. Given that, can you describe how, if at all, the standard for disqualification is different from party-appointed arbitrators? Kelly or Janet, please feel free to.
I'd like to interject on that one.
Okay.
I think the answer is very simple. It doesn't change. You have to be impartial. You have to be independent. If there's any submission on a challenge to that impartiality or that independence, based on some former relationship you may have with the firm who appointed you, what was the details of that relationship? Kelly talked about fact specific. That's what we want to see. That's what we want to hear. What was the relationship? It wasn't a direct relationship. Was it a continuing? Is it a continuing relationship? How substantial was it? Is it recent? Is it 10 years ago? These are the factors we're going to include, but there is no difference between party appointed, list selected, however that arbitrator is chosen. When a challenge is presented, that is not a factor we consider when a challenge is made. We're going to go by the facts presented by the parties. And I'll let my colleagues chime in on that if they think any different. And I do want to touch on real briefly Kelly's comment. Thankfully, very thankfully, it's rare that we get a challenge to an arbitrator based on their inability or refusal to perform. That thankfully doesn't occur. It's mostly on the impartial and independent statute.
Right, and I would only add to what Tom said, that, well, there's just one exception when the parties, agree on having non-neutral arbitrators. That's the only exception where we are not expecting, the arbitrators to be completely impartial and independent.
Which, thank you, Yanip, a great point. And because even in this day and age, parties can agree to do that. That has become rarer and rarer over the years, but parties can agree to have non-neutral party-appointed arbitrators, and that's not something we encourage. Believe us, we do not encourage that at all. Do not think it's the proper way, but it can happen.
Right, and that agreement needs to be in writing and completely clear.
So, Kelly, any other comments in this regard?
No, I was just going to make the point that Yanette made about the non-neutral arbitrator, which to me is just like an oxymoron, but like how can it be an arbitrator be non-neutral? But yeah, I've only seen it a handful of times. times. We have had one case come up to domestic ARC with a non-neutral arbitrator that was an objection, but because you can't object based on partiality and lack of independence because they're not neutral, it was an objection based on the inability to perform in good faith and with due diligence. And it was a stretch, and we reaffirmed the arbitrator. I think they just wanted the arbitrator gone and couldn't get under the other one because they'd already agreed that the arbitrators would be not neutral. Okay, thank you, Kelly. We have two more questions here, and the second one is from Steve Skolnick. What types of prior relationships between the arbitrators and the counsel or the party are most likely to lead to a successful challenge? Who wants to take that one? I'll pipe in for a second, and then Tom, I'll let you know, again, it's really, it is very case specific, but where an arbitrator or their firm, particularly if their firm is small, it might be a different analysis if their firm is like a Baker McKinsey, have an active representation adverse to one of the parties or adverse to one of the lawyers. I've seen a case where the arbitrator also had a litigation practice and so filed a pleading alleging bad faith against one of the party's law firms in a different case, but and just, you know, didn't make the connection between the two of them. So that's what we tend, that's probably going to be maybe the most problematic, but there can be other things as well. And it also depends on the industry. So like construction industry, everybody knows everybody, generally speaking. If you're in, you know, like Houston or LA, like all the construction people know each other and they all use the same experts and they know all of the arbitrators. And so things go to kind of a different level of analysis where you're coming from that standpoint.
Yeah, really not much more to add to that. In a lot of instances, and by no means limited to this, but you know, financial relationships are a big issue, and that's something we need to look at. And the facts need to be presented to us about that financial relationship, again, with the 4 factors previously outlined. An additional factor there also is, by the way, for me anyway, where we are in the case. You know, we're going to be a little stricter on arbitrators looking to get removed post-hearing, pre-award, where the writing is apparently on the wall and all of a sudden someone challenges an arbitrator based on whatever they submit. But to say, is there a clear and defining line that will get an arbitrator removed? Yeah, there probably is. And then I have to give you the fact specific. You know, last year, that arbitrator was hired by that firm and not one office of 40, but that firm that has 2 offices to conduct something for them. And I think there's going to be a question in a minute about prior services and arbitrators, so I'll wait to get to that. But this is in some other relationship. Thank you, Tom.
We have here another question from Luis Martinez. If it might be interesting to hear what does IR consider when the challenge is based on the fact that the arbitrator has been appointed multiple times by the same party? How does the IR deals with that?
I could start again, and anybody can jump in, please. I don't want to dominate this. I know my colleagues know. It can factor, but that's going to just depend on volume, recent, active cases, currently sitting as an arbitrator for that party. And when we say party, it's more counsel for the international cases. I'll let Kelly discuss domestic because we have caseloads that are very what I would call, they're repetitive in terms of a party. They're, you see these often in a consumer type caseload, an employment type caseload, but even some commercial contracts, B2B cases, where a party has a clause and they have lots of customers or clients, and there's repeat cases, so there's often repeat arbitrators. But in the international commercial scope, that repeat work as an arbitrator for an individual law firm could factor in, but I can't give you a specific answer that says there's a number. If you do it this many times, that's it, no more. It doesn't work that way. All these other factors have to come in.
Yeah, and just from a domestic standpoint, kind of what Tom said, that it's something that we look at. We definitely have caseloads, franchise, healthcare, construction, and others, where we might have a smaller roster than just, the generalist commercial litigator, transactional type of person. And so it's going to be fewer arbitrators. And if there's a large, they may get appointed or selected by the same party, and often the same counsel, because oftentimes it's the same party representing, or the same counsel representing the same party in a whole bunch of arbitrations over several years. And it is one of the factors that we look at. Just as Tom said, that we haven't established any kind of number of like, that's one too many cases. You can't. We're going to remove you. I actually know of some arbitrators who just personally are like, I already have 5, I'm not going to take on another one, or I already have whatever number. And so they decline appointments because they think it's starting to get to be too much. So it's something we look at, but as Tom said, it also depends on where the case is. It depends on where what the caseload is. If it's a more limited panel, and particularly if the party's contract says it needs to be somebody with this specific type of experience, and we don't have a ton of those people, and there's repeat cases, we're going to have the same arbitrator serving on the same cases. So those are some of the issues that we look at, but there's no right line of this is one too many.
Right, and just something I wanted to add is that, whenever there's a party raises this potential conflict, which is most likely happen when they, bring to the table that this arbitrator has been appointed several times, we also can ask the arbitrator to disclose exactly what are the circumstances for those appointments. And as Tom said, very fact-driven. It's to ask exactly how many cases, how in what period of time where those appointed happened. If we have a law firm with several offices, it may not happen. This arbitrator may have been appointed in one case with one office that it's not even related with the other one, or things like that. So we go back to the facts, and we also give the arbitrator the opportunity to explain whatever, or provide us with any additional information that may be useful to make a decision.
Thank you, Janet. We have 3 more questions. We'll try to address all of them. The next in the list is from Dave Wilson. He asks, what percentage of the challenges are based on failures to disclose? Please.
I don't think we have the stats on that in terms of failure to disclose. And I'm going to ask my colleagues to touch on this because it also relates to the follow-up question that's in the chat, Rodrigo, and I'm going to ask that they chime in. We have a responsibility as the administrator to receive the disclosures, if any, from the arbitrator upon appointment. And when we review it, we want to make sure that disclosure is as clear as possible. Now, you're talking about a failure to disclose. That is not as common as an incomplete disclosure. So I would ask my colleagues just to touch on what they do in their daily practice when they review disclosures of an appointed arbitrator, on how they may go back and forth and reach out to try to get more details. So I'll stop there and let them touch on that if they can.
For me, it has gone in two ways. First one is we normally ask the arbitrator to confirm their, availability to participate in a case. So that is like the first contact we have with the arbitrator. We give just very general information about the case, but that includes the names of the parties and counsel, so they may be aware of that, may bring any red light about any disclosures that may happen later when they receive additional or more information about a case. So in that first step, if I get something like, I have some, I'm not very sure because it has happened to me, this thing with this attorney, I know him from, some time or whatever. If that rings a bell, I have advised arbitrators to perhaps pass on that invitation and just wait for the next one, just because, it doesn't look completely right. So that is one. After that, when we receive the disclosures, a quick review, whenever we got a yes in the questionnaire, we circulate, obviously check on what information we have. And for me at least, is to try to be on the party side and see what information I got. And then if that brings me one question or any request for additional information, that's when I approach the arbitrator and say, you know what, we probably need more information in these. We need more details on what you are disclosing here. So that may, prevent for actually having a challenge later if we give the parties the full information and then the opportunity to consider that since the beginning.
Any other comments?
I just wanted to chime in that I've done some arbitrator training, mostly just locally, well, virtually, but for local arbitrators in the Midwest area, and focus solely on disclosures, because I don't think arbitrators not that they don't understand, but I really want to harp on them the importance of full disclosure, because I would say I'm not sure I've ever seen a less than full disclosure that was a purposeful failure to disclose because they in fact were biased for a party and they wanted the case. But I try to let them see, kind of as Yanette said, like looking from the party's perspective, particularly the party who's not the one involved with the arbitrator, it looks like you're trying to hide the ball. It looks like you're trying to hide something. And so, pressing them to make as complete disclosures as they can, keeping in mind their confidentiality obligations if it was a prior or pending arbitration or mediation.
Thank you, Kelly. So we had a lot of questions from Mira, but I think we have answered already here. So thank you, Mira, for a question. Now, we have another one from Greta Walters, and is if IARC determines that the administrative requirements to initiate an arbitration are not met, is the case dismissed or is the party given an opportunity to correct? If dismissed, would the party need to pay a new filing fee if it refiles? So maybe that's to Liz.
Sure. So there is a portion in the ICDR fee schedule that addresses deficient filings. So there is kind of a provision there that where a demand for arbitration is incomplete or otherwise does not meet the filing requirements, the ICDR will not proceed with administration. I do believe that, given the particular circumstance, that the party would, that the AAA or ICDR would request that party correct the deficiency. If they are able to do so and that deficiency is corrected, then we would move forward with administration. But if they are unable to respond or correct that deficiency in terms of the filing requirements, then there's an amount that AAA would keep, and then we would return the rest of the filing fee to that party. Of course, they can come back and file again if that's the situation, and we would review it then as well. But yeah, that's addressed in the fee schedule, and it's as an incomplete or deficient filing.
Yeah, and just to top that off, because it goes back even to this failure to disclose, we are never so draconian that we will just, on our decision, close a file. We are going to give parties opportunity to rectify a deficient filing or some type of situation. If an arbitrator fails to disclose and a party brings it up and an arbitrator comes running back saying, they're right, I apologize, here's the disclosure. We're not going to just remove that arbitrator automatically. We may give them an opportunity to rectify. Arbitrators are moving on these days. They're moving from firms into private full-time arbitrator roles. They may not have access to all those prior service as counsel for the 20 years they spent in a law firm. So we try to work with everybody not to end the process right then and there, but to get to a point where everybody's comfortable that it's proceeding and proceeding fairly.
Mm-hmm. I had a case in IARC recently where it was a filing requirements dispute for our purposes, and the AAA ICDR, we declined to proceed with administration with respect to non-signatories that were named in the proceeding, but we proceeded with administration as it pertained to the signatories to the agreement. And then the parties were, free to raise the issue of those additional parties being joined to the arbitrator once appointed. But the council's determination was that, administration with respect to the non-signatories could not proceed as the filing requirements were not met with respect to those additional parties.
Thank you, Liz. Any other comments from the panelists? Okay, we have here a final question from Shazia Yunus. Any trainings, workshops for international arbitration and mediation by ICDR should be possible in a near future? So Shazia, I think you can follow ICDR.org, and then there is a section of the events there. And maybe Rafa can also touch on that later on. I think the time now is up. We need to resume and conclude this webinar. So thank you all once again. And now we'll defer to Rafa for the final remarks. Please, Rafa.
Oh, perfect. Thank you very much, Rodrigo. And yeah, I'll post now before finishing a link to YNI website where, as I mentioned, we have all the recorded programs that we've had. And also I will mention in response to the last question that there's also AAA-Education.org, I think it is. And you can check there a number of online courses that are available and upcoming programs. Of course, on top of what Rodrigo mentioned, just our general ICDR.org website, or if you go ADR.org website, that's the AAA-ICDR main website. So with that, I don't want to take any more time. I don't have anything else to add to the excellent presentations and comments of our panelists. I thank everyone who joined this webinar today. I thank our great panelists and moderator. And I hope to see at least some of you in our upcoming webinars. Thank you all very much.
Thank you.
Thank you. Be well.